When you're in public service, just having good intentions isn't quite enough. Especially in Missouri, a single wrong move on a conflict of interest issue can pretty much end your career. So today we're going to break down the rules you absolutely have to know, starting with a situation that might feel a little too real.
Okay, so just imagine this for a second. You're brand new in office, you're excited, you're ready to get to work, and then a city contract opens up and your own brother's company puts in a bid. This is more than just an awkward family dinner conversation waiting to happen. This is exactly the kind of scenario Missouri's ethics laws were designed for. What you do next is absolutely critical. So the first and most obvious problem here is something called nepotism. And in Missouri, we're not just talking about something that looks bad. It's a hard, bright line drawn right into the state constitution itself. There's really no gray area here. And the Constitution is super specific about it. This isn't a suggestion, it's a flat-out prohibition. You can't appoint a relative who's within the fourth degree of relationship to any public position. And that means a full-time job, a part-time gig, even hiring them as a contractor for a small project. The law actually defines relative in two different ways. The first is consanguinity, which is just a fancy word for relatives by blood, parents, siblings, cousins. The second is affinity, which covers relatives by marriage or adoption. Now, what's interesting is that an affinity relationship can actually end if there's a death or divorce, which can change where these legal lines are drawn. So what in the world does fourth degree actually cover? Well, as you can see, it goes out way further than you might guess. First degree, that's your parents and kids. Second degree covers your siblings and grandparents. Third degree, you've got aunts and uncles. And that fourth degree, that includes your first cousins and even great aunts or uncles. If your relative or your spouse's blood relative is anywhere on this chart, this rule applies to you.
And the consequences for getting this wrong, they are swift and severe. It's not a fine, it's not a slap on the wrist. If you violate the nepotism rule, you automatically forfeit your office. The law is that blunt. End of story.
Okay, so nepotism is one very clear line you can't cross. But the rules go way beyond just your family tree. What if the company bidding on that city contract wasn't your brother's? What if it was one that you owned a piece of? Well, that opens up a whole different can of worms about your own financial interests.
For these situations, the law uses a specific measuring stick. It's a key term called a substantial interest. This is the legal standard that decides if your financial connection to a company is big enough to be a real conflict. And it's not based on a gut feeling. It's all about hitting some very specific numbers.
And here are those numbers. A substantial interest exists for you, your spouse, or your dependent kids if you meet any one of these three tests. You own 10% or more of a business, you have an investment in it worth $10,000, or you get paid $5,000 or more a year from it. Hit just one of those and you are officially in conflict of interest territory.
Now here's the thing. Having a substantial interest doesn't automatically mean your company is banned from ever working with the government. But, and this is a big but, it means you have to follow a very strict, very public process designed to keep everything fair. So, how does that actually work?
All right, here's the first number you need to burn into your memory. $500. A business owned by an official can do a single piece of business with their government entity up to this amount, no special rules required.
And here's the second number, $5,000. This is the max you can do in a whole year, across all transactions combined, before those special rules kick in. So you could have a few small jobs, but if they add up to more than $5,000 in a year, you've crossed that threshold.
The moment you go over either of those limits, 500 in one shot or $5,000 total for the year, the game changes. The law puts up a huge guardrail. That contract has to go through a formal, public, competitive bidding process.
And that bidding process has a giant catch when a public official is involved. First, you have to publicly announce the bid so anyone can try for it. Second, all the bids are sealed. But third, and this is the most important part, if the contract goes to the official's company, it must be the absolute lowest bid submitted. Not the best, not the most qualified, just the lowest. Period.
So, with all these potential pitfalls, how do you manage everything and make sure you're protected? The single best tool any public official has is transparency. And that really comes down to one thing, disclosure. It's about getting all your potential conflicts out in the open.
The formal way this happens is through a document called a Personal Financial Disclosure Statement, or a PFD. Think of it like putting your financial cards on the table for everyone to see. The whole point is to create transparency and keep everyone accountable.
And this form isn't just a piece of paper you fill out once a year. It's a legally required step.
If a vote comes up that involves a business you have a substantial interest in, you are not allowed to participate unless you've already listed that interest on your PFD.
At the end of the day, it all comes down to one simple, powerful mantra. When in doubt, disclose. You can't get into trouble for being too transparent, but you can absolutely get into trouble for hiding something. It protects the public, and frankly, it protects you too. All right, so you've got all these rules, but rules don't mean much if no one's enforcing them. So who is the watchdog here? Who's making sure that public officials in Missouri are actually playing by the book? Well, that responsibility falls to the Missouri Ethics Commission, or the MEC. And their own mission statement says it all. Their job is to promote transparency, accountability, and compliance. They are the independent body in charge of making sure these standards are upheld. And the MEC has real authority. They don't just ask nicely. They investigate complaints that come in from the public, they audit those financial disclosure reports we just talked about, and they have the power to issue penalties when they find violations. It shows that these rules really do have teeth.
And that brings us right back to the big idea here. These rules about family, about money, about disclosure, they're not just red tape. They are the absolute foundation of public trust. When officials are transparent, it tells everyone that decisions are being made for the community, not for personal gain. So here's something to think about. In your own community, how does seeing this kind of transparency in action build your trust in local government?